Wel, bore da, chroeso I Landmark. Russell Harris, QC ydw I. Gyda fi heddiw yw James Maurici QC a Heather Sargent. Welcome to Landmark Chambers webinar. It's called Delivering Infrastructure in Wales, Current Issues. My name is Russell Harris QC. With me are James Maurici QC and Heather Sargent. We are delighted to see so many of you joining the session today. It's a very, very powerful and wide-ranging delegate list from Wales and indeed much wider. I will chair the session today. I've got two screens in front of me, which for me is the equivalent of piloting the Starship Enterprise, so bear with me. I will formally introduce myself and my colleagues in a moment, but first, a few housekeeping points. First, your microphones are automatically muted. You won't need to adjust them. You won't need to adjust any of your local settings. Second, we very much welcome questions throughout the session. Please submit them via text in the Q&A section, which you can click at the top or bottom of your screen. It's at the bottom of my screen. It's a click and your messages will be sent through to the panelists' questions. Third, we will try and answer as many questions as possible. We're going to do it at the end of all three presentations. Fourth, this webinar is being recorded and all delegates will receive a link to the presentation and the recording shortly after the event concludes. If your connection is lost at any point during the webinar, simply rejoin the meeting by clicking on the original link once more and you should get through to us. So let us begin. I'm going to introduce my fellow panelists first. First, Heather Sargent. Ma hi'n dod o Wrexham yn y Gogledd, and aside from her North Wales origins, she's a member of the Welsh Government's B panel of Junior Council. She acted for developers in the successful challenge to the refusal of a consent for a wind farm in mid-Wales. Many of you will remember that from 2015. She advised Welsh ministers in relation to the M4 corridor around Newport, and she's got much broader infrastructure experience, including extensive CPO experience, advising clients including Highways England and Gatwick Airport in relation to DCO applications, and importantly and impressively, she is advising national government in the UK on national policy statements relevant to NSIPs, including defending the airport NPS on behalf of the Department of Transport and advising UK government on the new nuclear NPS. Turning to James, James Maurici QC, ma fe'n dod o Gogledd hefyd, ond Gogledd Llundain. James also comes from the north, but from North London. However, he knows Wales and Welsh policy very well. He's acting for Menter Môn on the Morlais tidal stream energy project off the coast of Anglesey, which is the subject to an inquiry very shortly. He regularly advises NRW on environmental issues. As a junior, he was on the Welsh Government's Junior Council panel and did many of the largest Welsh planning cases. And he is publishing with others in Chambers this autumn, so watch out for it, a book. It's called A Practical Guide to Planning Law and Rights of Way in National Parks, Broads and AONBs. The book covers Wales, and James it is who is writing the Wales policy chapters. He has promised me, but with a sparkle in his eye, that he won't plug it shamelessly during this talk. He's a Spurs supporter, and of course we all know that most of Spurs' success was built on its Welsh players, all the way from Cliff Jones through to Mike England. And Bill King, my clerk, tells me that Jimmy Greaves was Welsh, but I rather doubt that myself. All right, and me, wel, fy ges I fy ngeni yn Mhondlotin, yn y Cymrymni. I was educated at Hale the Comp, which many of you will know was the old Bargoed Grammar Technical Mining School. In Wales, I successfully got the consent for the Western Bootstrap for National Grid. That's the subsea cable and converter stations from Scotland down to North Wales. Again, I piloted successfully the DCO for the Wylfa connection for Western Power, and I'm presently acting on DCO applications for National Grid in relation to Wylfa and Newydd and Mid Wales Wind, both of which I'll mention in my talk, which comes shortly. Outside Wales, I'm probably best known for acting on architectural cases such as the Shard, the Gherkin, and the Walkie-Talkie 20 Fenchurch Street. I'm going to talk first, and I am going to talk about infrastructure in Wales generally. The purpose of this talk is really to give people a high-level overview of the changing consenting structure that has taken place and is going to take place in the future in Wales. I'm going to look also at some key decisions and give some commentary which is my own opinion of where we sit at the moment and where we should be going. So that's the talk that I'm now going to start with. So the system in Wales at the minute is not straightforward. There are at least three, I say three or more, consenting regimes. First up, there's the nationally significant infrastructure projects. They are NSIPs. They're the Planning Act 2008 projects. They are projects which are in or partly in Wales that relate to non-devolved, mostly energy, non-devolved and identified important infrastructure projects set by Section 14 of that Act. So that's the first category of infrastructure projects in Wales. They are determined by Westminster ministers following reports from planning inspectors who sit as examining authorities. Second, there are the Welsh ministers' decisions. These fall into two categories. There's developments of national significance, or DNSs. They are the planning projects in Wales which are devolved and nationally important in the context of Wales. Recently generating projects up to 350 MW and all onshore wind projects have been passed to Wales ministers. We'll see they aren't all following the same route to consent, which is a complication that I'll speak to in a moment, but they're all decided by Welsh ministers. Then there are a barrage of other projects which are brought forward under planning, electricity, highways and other legislations. They're mostly determined by local planning authorities, sometimes by the First Minister, but there are a range of powers and consents that are sitting for infrastructure purposes beneath and beside the NSIPs, which are determined in London, and the Welsh ministerial decisions, which are made in Cardiff. Well, there have been some recent changes, and there are more to come. The 2017 Wales Act, by Section 39, devolved the power to determine infrastructure projects to Wales, further infrastructure projects. Most importantly, it increased the size of on and offshore power projects that could be determined in Wales up to 350 megawatts generation. These projects were therefore removed from the English and Welsh NSIP list and are from now on, if they're up to 350 megawatts, to be determined in Wales. Onshore wind projects of any size were already devolved to Wales by way of the 2015 Act. So how did this repatriation or transfer of powers take place? Well, the Act, the Wales Act, returned these powers in a rather anomalous way. And that has led to the need for what the Welsh Government has called an interim system of consenting by way of various complex statutory instruments, 11 statutory instruments in total. They came into force in April 2019 and in effect made the larger onshore transferred power generation cases, DNS, It also allowed for transmission lines associated with those generators to be treated as DNS, but rather than get the Welsh Government to determine every single last one of those, because there will be many, it allowed those to be determined by an appointed person, namely an inspector. So for the first time in the large infrastructure world, the decision powers were delegated for DNSs to PINs to examining authorities or inspectorates. In addition, offshore generators of up to 350 megawatts are also Welsh decisions, Welsh ministers' decisions, but again, for reasons set out in the consultation documents, the mechanisms which are used for the offshore generators remain those of the Electricity Act. So you already begin to see that there are a myriad of potential consents and routes to consents, not straightforward. So why was an interim-based solution for infrastructure introduced? I think the summary is that Wales was keen to get the powers back, but the optimum position for determining infrastructure wasn't yet ready. And so we've had to go for this interim position. It's an interim position because Wales Government has announced its intention to identify for specified infrastructure projects, including energy, a one-stop shop infrastructure consent in Wales. And it's called the Wales Infrastructure Consent. It's not in place yet, and it requires primary legislation. It wasn't ready for the April 2019 extension of the powers of Welsh ministers. Hence, we've ended up with a rather scrappy interim solution that I've already outlined. Also, the Act, the Westminster Act, returning the powers or transferring the powers to Wales, did it in a rather strange way. By default, it returned the powers to local planning authorities, leading to a perverse hierarchy of decision-making, where very small power generation was determined by local authorities, medium by Welsh Government ministers, and larger, up to 350, again backed by local planning authorities. And that was seen to be perverse, hence the need for the 11 statutory instruments. Both the interim and the one-stop solutions have been the subject of consultation. That consultation has closed, and the interim solution came into force, as did all 11 statutory instruments, in April 2019. And the Welsh Government has published these helpful documents. They identify the current consenting process as was, and the future consenting process as now is. And the key things to look at are these bottom cells, because now we are in the future world. And what they show is that for wind energy, this is the wind energy slide, for everything over 10 megawatts, the Welsh Government now has control. No upper limit. Anything to do with onshore wind is Welsh Government. Offshore, up to 350 megawatts, Welsh Government ministers, but note, the process is the Section 36 Electricity Act process, which offshore developers were used to, and it was thought not appropriate to shift. But you've got a different mechanism for granting of consents offshore to onshore, and over 100 megawatts is still an NSIP, and all NSIPs are determined at Westminster, subject to local impact reports and consultation with NRW and the Welsh Government. That's the wind energy generation position. Other than wind, the position is one stage more complex, because after the Act, anything under 350 megawatts is determined by the Welsh Government via the town and country planning position and the relevant SIs. Anything over that, nuclear power stations like Wylfa Newydd, for example, are determined by the UK Government. Then offshore, we've got up to 350 megawatts. Non-wind is determined by reference to Section 36 of the Electricity Act, again, for the same reasons. And over 350 megawatts, goes to the UK government. There's the position as set out in the Welsh Government's own literature. So what's coming after that interim position? We've got the 11 SIs at the minute divvying out the route to consent, and were they divvying it out in various locations too? Well, after the interim, what is proposed is a new Wales infrastructure consent, and this seeks to mirror the NSIP position in England, but to be sharper, quicker, and more agile. It's just not enforced just yet. But that is the underlying theory of it. And the Wales Infrastructure Consent seeks to consolidate existing consents under the Town and Country Planning Act, the Electricity Act, Harbours Act, and a number of other consents made under highways legislation into one single type of consent with its own process and procedure. The Wales Infrastructure Consent would also include a wide range of secondary consents, including, importantly, compulsory purchase orders. It would also allow marine licenses and environmental permits, all of which, compulsory purchase and marine licenses in particular, are flaws of the system at the minute, because Welsh ministers, when dealing with projects that are of importance to Wales, sometimes lack compulsory purchase, and also developers are finding they're needing to go elsewhere for marine licenses. In short, it's to be a one-stop shop. And I cross-referred between the Wales and the English documents just to see how that would translate as a Welsh learner myself. One-stop shop has a sort of English idiomatic poetry to it, and I was expecting something like shop, un stop, or something similar in Welsh. Nothing like it. In Welsh, it's a simple process of consenting. So very much more literal and less poetic for once in Welsh. So the consenting process would be accompanied by thresholds and policies against which the individual projects could be assessed, much as Heather is advising Westminster on NSIPs. Now, there's no fixed date for the introduction of this system. The most recent guidance states it won't be 2020. Well, you can say that again. It's tied up with the National Development Framework, which has been sort of adjourned sine die at the minute as a result of COVID. My estimate is that we won't see much before 2022, but there may be others on this webinar who are able to assist with that. But that's what's coming. Watch this space. The proposed categories for the Wales Infrastructure Consent will be very familiar to those who operate on NSIPs. They're there set out. I don't need to read them out. I don't think there's anything massively surprising there. They are the usual infrastructure categories that would benefit from a one-stop shop process. The consequences of the new consenting regime, these are some examples and a feel for the changes. And they aren't mine. Interestingly, this is what the Welsh Government sort of publicity department, the research department sought to put out as an explanation of how the new system would work and how they would see it operating. So the Wales Act 2017 and the interim arrangements, the 11 statutory instruments put in place last April, what they mean? Well, they mean that smaller energy projects would now be determined in Wales, not Westminster. And the one example that the Welsh Government chose themselves to identify as being caught by that would be the Swansea Barrage tidal lagoon. That would now, if it were to be the subject of an application, be an application for a Welsh consent. It would be Swansea Barrage tidal lagoon determined in Wales, not Westminster. That's because of its capacity. On the other hand, as the government's guidance note points out, the huge Wylfa Newydd power station on Anglesey would remain with Westminster for all purposes. It would be an NSIP, it would be significantly above the 350 MW threshold. And third, the M4 link road in Newport. By this stage, the government had rejected the M4 link road, but it still appears in the Welsh Government's identification of the potential for change. The M4 link road in Newport would have been eligible to be consented by Welsh ministers, not by Boris Johnson. I'll come back to that as a result of something he's saying in Parliament at the minute, would be eligible to be consented by Welsh ministers under the new streamlined one-stop shop infrastructure consenting regime when it was eventually enacted, as opposed to the much more cumbersome series of consents, highways planning, CPO provisions, which led to almost a year-long inquiry. So that it gives you a feel for how the changes will work over time. We've also now got a Welsh National Infrastructure Commission to assist in identifying where the infrastructure needs to go and how it should work. Its first annual report has been published. It's made a call for evidence and expressed its preliminary and provisional findings. The need for infrastructure provision, it finds, is substantial and wide-ranging, from large projects down to small mobile telecommunications projects. But these are early stages for the National Infrastructure Commission. I don't dwell on that any further. Which brings me to my first comment, my first pause and reflection on where we are. The infrastructure consenting regime in Wales self-evidently is and has been complex for at least a decade. In NSIPs, the National England/Wales nationally significant projects, the junction between devolved matters and non-devolved matters on large infrastructure projects has not always been clear, as we'll see. And the law and decisions on associated development and other consents have been confused and confusing, sometimes indeed pointing in diametrically opposed ways. Third, the incremental and bitty transfer of powers from Westminster to Cardiff, particularly in terms of energy, and then the inability to synchronize the repatriation of powers with a one-stop shop consenting regime is unfortunate, to say the least, and will require, as a result, at least two messy series of transitional arrangements and some further years of confusing multiple systems. And I say therefore, it's hardly surprising that inward investors, who turned up to the M4 inquiry in large numbers, by the way, have not been flocking to provide the infrastructure which is much needed in Wales. And in certain sectors, marine development in particular, Wales is now at a significant procedural disadvantage to some parts of England, when the small and more nimble planning system that Wales should have should put it at an advantage, not a disadvantage. There's the reflection. I want to look at some NSIPs now, because there have been some successes and some failures. So I'm going to look at the three regimes in turn. NSIPs first. It didn't start well. It didn't start well because the first ever DCO application to be rejected or not accepted as valid by PINS was in fact a Welsh DCO. And I don't find it surprising that the first few applications were not accepted, because the acceptance process is quite onerous. It involves a consideration of two, sometimes three, pre-application consultation processes. And I'm bound to say, as somebody who's now been involved with, I think, 9 or 10 DCO applications, the wait for the DCO to be accepted by PINS and the department, particularly in complex linear projects, is a very nervous one indeed. The standards for acceptance are high, and particularly in the early years, were not massively well known by submitting teams. Since that time, the PINS website records 18 Welsh NSIPs, either determined, at decision stage, or still in flight. I know, as a matter of personal knowledge, that the website is not absolutely fully comprehensive, but it does give a very good feel as to the nature and type of NSIPs being determined by Westminster. They're almost all energy-based, not all, but almost all. Of the 18 projects on the PIN site, 12 are decided, 11 have granted, 1 is refused, 1 is pending, which is Wylfa Newydd, the nuclear power station on Ynys Môn. 5 are stated to be in pre-app, but 2 of which I am involved with and to my certain knowledge are, at least for now, stalled and unlikely to proceed soon. Some of the most noteworthy and newsworthy I consider now. Swansea Tidal Lagoon has been massively in the newspapers, on the press over the last 4 months. Many of you will know it. It is a very early DCO case and a very interesting one from a whole range of perspectives. First, you will remember that the tidal lagoon was very much more than a tidal lagoon to start with. It was a tidal lagoon stroke commercial stroke leisure stroke tourist use, and the local authorities involved and the Welsh government, I think correctly, said, well, hold your horses here. This is much more than an NSIP, and it's trespassing on our devolved jurisdiction to deal with those other matters which are not energy-based. As a result, I'm sure, of advice, the promoters of the scheme removed significant elements of the leisure to deal with that issue. Next, the issue of how to deal with marine licenses and whether the powers of the 2008 Act were sufficient, and they are massive in their scope, but whether they were sufficient to extend the planning jurisdiction of City of Swansea and Neath Port Talbot to offshore was considered. The examining authority took the view, agreeing with the developer, that the local authorities could extend their power, which would mean a much more streamlined approach, but that was rejected by the government in Westminster, which meant that there was therefore the need for additional marine consents, and that jurisdictional extension of power was thought to be ultra vires. A very interesting debate for public lawyers. Third, there were many, many pre-start conditions or requirements, as they're called on a DCO, including a requirement to submit details of how the plant would be decommissioned at the end of its useful life. Very important consideration arising from European legislation and directives. Watch this space, because that comes back in the next slide. There was a long examination in public. The Westminster Secretary of State accepted the PIN's examining panel recommendation and granted the consent order, the DCO, including CPO powers, which must have meant that the Westminster Secretary of State thought there was a compelling case in the public interest. That was in 2015. As many of you will know, by 2017, the Secretary of State, Greg Clark, made a parliamentary statement indicating that the project fell far short of what he said was value for money, and would therefore not receive the needed UK government funding or spot price fixing, placing its future, that's the whole project's future, in doubt and delaying the start of the project. There was, you'll remember, uproar in the Welsh government and among Welsh MPs, and it was not a happy moment for devolution and the relationship with Westminster. It also meant that the developers needed to seek funding from elsewhere, which of course took time. Now, what's happened recently? The question now arises as to whether the DCO has been implemented and therefore safeguarded in perpetuity, or lost and therefore lost. Well, the DCO was a 5-year consent. No application for an extension was ever made, although that power does exist. There were, as we've seen, a series of pre-commencement requirements, and just before the expiry date in June 2020, and in the midst of the COVID crisis, the operator and its lawyers claimed that the works had been done, and as a result, the project had been saved in perpetuity. For those in Wales, you'll remember there was a big press and TV campaign. The wall, which had been demolished, was filmed with various people standing in front of it. It was said that the wall had been demolished in compliance with the DCO, and as a result, the DCO was saved forever. But The Secretary of State in Westminster, Kwasi Kwarteng, and his lawyers, and Swansea Council and their lawyers are very clear and have issued 2 public statements to the effect that the consent has not been lawfully implemented because, among other things, of the absence of a pre-commencement compliant decommissioning strategy. And they say, as a result, the DCO has been lost. The Secretary of State also refused to save the DCO by a specific act of Parliament, which he could have done and did in certain other circumstances, but didn't in this case, not least because he said the project had been shown to be not good use of public money. See Greg Clark's statement. Now, we've got 2 sets of lawyers saying 2 different things. There is therefore an inevitable legal battle coming. And with both sets of lawyers clear that they're correct, it's difficult to call without seeing all of the papers who's right. The issue will undoubtedly turn on the proper interpretation of the DCO requirements, the status of the submitted decommissioning report, which was submitted, and its relationship to the works of demolition undertaken on the site and whether they comprise within the development. Obviously, the Whiteley principle, which states that you can't implement a planning permission by doing unlawful works, is at play. But as you also know, there are exceptions to the Whiteley principle, and it is the nature and extent of those exceptions that I expect to play large in this litigation, if there is to be litigation. The immediate lessons are obvious, and they are: first, if you are seeking to implement a permission or a DCO, please make sure that the act of implementation is simply not capable of being argued over, or seek an extension of time under the relevant provisions of the 2008 Act before time runs out. Obviously, there are very good reasons why that might not have been possible in the circumstances of this case, but the general rule ought to be that. The second lesson, though, is a wider lesson for Wales as a whole, and it may not be Wales government's fault. It may be that the fault lies significantly elsewhere, but the wider impression given is of confusion, governmental change of heart, and overall difficulty of infrastructure delivery in Wales because of complications connected to the devolution settlement. So the first 2 projects on the PINS website are Swansea Tidal Lagoon and Wylfa Newydd, and they probably are the 2 biggest infrastructure projects that PINS is dealing with. Wylfa Newydd is a new nuclear station at Wylfa, and it really building on Ynys Mon's wish to be the energy island and reflecting the reliance on the existing power station that Anglesey has. Anglesea's economy was set to be boosted by the construction of Wylfa Newydd Nuclear by mid-2020s, a joint venture to begin with, then a Japanese parent firm taking over. The principle of the power station, the new nuclear power station at Wylfa, had largely political support in principle, across parties, and not so the transmission, by the way. I was acting for National Grid in relation to the transmission, which was overhead pylon across the island. That was much more controversial. Now, just before the examination began last year, the Japanese parent company and promoter Hitachi announced that it would no longer be proceeding with the project because of its inability to agree a price regime with the government in Westminster. Now, a decision then had to be made. Did the examination stop or did it go on? Well, the examination continued, and it continued to a conclusion. The inspector's report has been received by the Welsh government, by Westminster, of course. This is an NSIP, and a decision is expected in September. But don't hold your breath, because that decision has already been put off on at least 2 separate occasions. And of course, the Westminster minister has the power to put it off further. The big issues that arise are clear. The examining authority's report has been received, And there have already been 2 sessions of post-examination consultations from the Secretary of State directly. The first deals with impact on terns and habitat, all of which arise out of the potential funding of mitigation and also the way in which that mitigation is going to be delivered in the absence of support from the parent company. And the second, and linked, are the consequences of the parent company decision to withdraw funding across the board, and also to withdraw many ancillary applications which were needed for environmental matters because the NSIP is in Wales. All of those, not all of them, but the vast majority of those environmental consents weren't proceeded with, and the Secretary of State is now seeking assurance as to what's going to happen in relation to that in the event that he or she grants the DCO. Critically, there's been no apparent movement on the funding or pricing issues between the parent company and Westminster. And critically also, funding has been confirmed as being withdrawn. The DCO application for the transmission infrastructure, the overhead pylons, which was accepted and was due to continue to examination immediately after the power station examination, is not now being proceeded with, and no alternative transmission solution is in train. The existing electrical infrastructure is insufficient to allow meaningful transmission in the short run, and therefore, my last paragraph here, there can really be little prospect of this project being delivered consistent with any realistic political wish. For one reason or another, the infrastructure process has again in Wales failed. Now, control of pricing and of decision-making at Westminster means that a politically important project has been placed in significant jeopardy. There have, however, been some successes. This is the list taken from the PIN's website. Hirwaun Power Station was, I think, the first one where the issue of whether an underground cable could be consented as part of an NSIP, it not being a Section 14 project, but that was, how can I put it, fudged in that decision. Wylfa and Clwcainog were mid-Wales farm, Tan 8 type wind farms, and over the page, Wylfa Forest Connection, which I did, again, brought those wind farms into the grid. The main issues there, I'm bound to say there were visual issues, but it was a wood pole transmission, so they were less keenly felt. The main issues there were compulsory purchase issues and wayleave issues, which the examining authority was very, very keen, rightly so, to ensure that farmers and landowners were appropriately and fairly dealt with. North Wales Wind Farms is, I think, probably the most recent connection that's been granted a DCO by Westminster. Then there's the one refusal, which Heather's going to talk about, so I'm going to leave that to her. The simple point here is that the Westminster Minister believed that the Red Kite SPA had been inappropriately dealt with in terms of evidence, insufficient evidence to make a decision, and that has featured large elsewhere in other cases that Heather will speak to also. So my conclusion on NSIP delivery in Wales, the avowed aim of NSIP delivery across England and Wales was to make the infrastructure delivery system easier, gaining the early support of communities through front-loading. I am bound to say that the multi-phase pre-application consultation I found not to be consensus forming, rather the reverse, and quite often those interested and those who clearly are genuinely wanting to object find the whole process of 2 or 3 pre-application consultations rather baffling. They want to know what the project is likely to be, how they can shape it, and one pre-application consultation I would suggest might be more appropriate, but that's a personal position. Overall, smaller scale energy projects fare reasonably well. But larger scale projects, critical to the economic well-being of Wales, whatever your view of the merits, don't fare well, either in a procedural sense or in a sense of substantive conclusion. That's my conclusion on NSIP so far. Then there are developments of national significance. These are the planning cases that are nationally important in the context of Wales. There are 35 of them on the PIN's website at the minute, but only 2 are yet being recorded as determined, 1 grant and 1 refusal. And if you look at when those applications were submitted, it can hardly be said that this is a streamlined system that is producing significantly more or quicker decisions in its relevant fields. But many are now identified at the decision stage and expect a rush of decisions shortly. And of course, we've all been living with COVID, which is a proper and meaningful reason for decisions not having been made. But the research that has been done by the Welsh Government themselves indicates that the average time of determination is not, in many cases, in many sectors, not materially quicker than it would have been had you gone through the planning position with the local authority. But it's too early to say how the system is working in truth, and it will, this DNS system, be a very short-lived one if the WIC regime comes in. Note again that the 1 refusal in this sector was on habitat species grounds, re-emphasising what Heather's going to tell you later. So I'm turning now to the third and final category, which is the bespoke applications that have to be made across various regimes. And I'm going to concentrate on the M4 link road. Some have called it a shambles, some have called it a missed opportunity. It would undoubtedly have been the largest infrastructure project in Wales over the last 30 years. It is a notorious and poor gateway to Wales, is the M4 around Newport. It suffered from severe and expensive congestion at many times, but particularly in the important early AM peaks. It's long been recognised as a constraint to economic growth. It's universally accepted to be something that needs an infrastructure-based solution. Since 1991, 5 schemes have come, gone, been shelved, refused, come, shelved, refused. 5 sets of schemes. The most recent one went to inquiry in 2018 and 2019. It was almost a year-long inquiry costing over 50 million, considering the 34-kilometre route. It was promoted expertly, I'm about to say, by Maurici QC. She promoted the scheme and called over 30 witnesses acting on behalf of the Welsh Government. They described how the proposal met all the strategic and local policies for the area and the nation, described its economic effects, and that it constituted value for money. It was supported by the CBI, a barrage of potential inward investors, a large number of inward investors who cited the physical constraint of access as the main reason they weren't here. Almost all relevant local authorities, but there were strongly and sincerely held environmental and amenity objections also. Independent inspectors found in favour of the proposal. It's a good decision, it's a good inspector's report. Read it if you've got 3 days. They conclusively ruled out all 18 alternative solutions and all other routes, and advised the First Minister that his own Welsh Government's case had been proven and that the benefits significantly outweigh the harm, and that as a result the orders should be made. Well, it didn't go that way. The First Minister, Mark Drakeford, who'd just been put in post, because the previous First Minister, Carwyn, had long championed the link road as a matter of principle, but the new First Minister set aside the recommendations of the independent inspectors. He did so on the 4th of June 2019. In a very short decision letter, he explained that his operative and main reason for not making the orders was that, notwithstanding the fact that the Welsh Government itself had actively and fully promoted the scheme, both at the inquiry and in all of its policy documents, the Welsh Government Cabinet had, in April 2019, now decided that the road could no longer be prioritised in the forward capital programme budget, having regard to resources and other commitments. And in such circumstances, and for that reason alone, he said he would not make the orders. Then he went on to explain that he didn't have to consider the balance of the benefits and harms as part of his decision, but that he had, and that he had found that the unacceptable ecological and other harm to the Gwent levels would be outweighed by the would not be outweighed by the benefits of the projects. Now, a comment from me: the decision stands. The decision is lawful because it hasn't been challenged, and that's how decisions work. I also appreciate the quasi-judicial position that the First Minister was in. He had to look at the report and form his own judgment without prejudging or predetermining any of the issues. But without needing to express a view on the merits at all, and there will be people on this webinar who would be very firmly in favour, and also some that would be massively against, just look at the overall process, please. The overall process involved in making this decision does not paint the delivery of infrastructure or the infrastructure consenting processes in Wales in a good light. The Welsh Government had been consistently supporting and fully promoting the Relief Road for decades, including through published policies, each of which had been the subject of strategic environmental assessment. They paraded, not months before, 30-odd witnesses, some very senior policy witnesses, in support of the project, only for a political decision that priorities made in the shadow of the inquiry to scupper delivery. I just ask the question, forget the merits, how does the process speak about infrastructure delivery in Wales to potential investors? And finally, and again, this is a personal view, the decision of the First Minister then to express a wholly unnecessary, and he explained it was unnecessary, and superficial finding, just 3 paragraphs, on the balance of benefit and harm was politically inept, I say, and it reduces the likelihood of central government funding in the build, Rooseveltian New Deal promised by Boris Johnson. It makes that, it reduces the likelihood of that happening. What Boris is saying in Parliament at the minute is, I will give Wales its relief road. He hasn't got the power to do that, not the administrative power, not the decision-making power, but he well could underwrite the costs and make it a much more realistic proposition. And that will be a more difficult task as a result of the unnecessary and superficial finding, the add-on finding towards the end of the decision letter. Which brings me to my conclusions. Wales needs more and better infrastructure if it's to be competitive. The scale of the infrastructure needed is huge. As we've seen, the record of large-scale delivery is rather poor. The consenting regime that we presently have is accepted by all to be not fit for purpose. The reason for that is that the devolution settlement, a very good thing in my mind, paid insufficient attention to the consequences of infrastructure planning, leaving a system which is complex and cumbersome. So something like the Wales infrastructure consent process should have been in place earlier, in my judgment, and should have been in place before the transfer of further powers to Wales in April 2019. It hasn't been, we are where we are. So what we need now is that system to be put in place urgently as soon as is possible. In the meantime, the operation of effectively a dual interim system with 2 sets of transitional arrangements means that there is going to be uncertainty and a reluctance in some to invest at a time when post-Brexit, Wales will need all of the competitive advantages it can muster. For those giving advice, those on this call, for those operating within the system, care, patience, and a good working knowledge of the myriad of consenting regimes and procedures will continue to be necessary. That's it from me. Diolch am wrando. Diolch hefyd am y cyfle I ymarfer siarad Cymraeg. I've tried to use the lockdown to connect better with hen iaith, and I'll be brutally frank, it's a bit of an infrastructure project in its own right. Nawr mae James and Mindy siarad am parciau genedlaethol. I'm passing over to James to talk about National Parks and AONBs. Diolch pawb.
Hello. Hi. So I'm going to cover, as Russell just said, delivering infrastructure in or close to national parks and AONBs. And I feel I've got to start with a little bit of an explanation about why I've chosen to talk about that subject. And there are really three reasons. One is, as you'll all know, it's a very common issue on infrastructure projects in Wales because the three national parks themselves make up 20% of Wales. One then has to factor in the 5 AONBs, 4 of which, of course, exclusively within Wales and one of which crosses the border. And so in total, as Planning Policy Wales tells us, a quarter of all of Wales is covered by these two important designations. And one sees the extent of the coverage from that map. Secondly, there are a surprising number of legal issues on the meaning of the relevant policies that govern national park and AONBs in terms of landscape impact on them. The wording in PPW on the protection of parks and AONBs has differences to the same sort of policies we have in England. And it's important to understand and appreciate those differences. There are in England quite a large number now of higher court authorities looking at these policies. And as will become clear as I proceed, some of the reasoning in those cases I think applies to Wales and some of them does not. And then finally, to breach my promise to Russell and to plug the book, the third reason I'm talking about this is that these are issues that I've had to look at both in terms of England and Wales, and indeed also Northern Ireland, in writing relevant chapters of the book, which is coming soon. So if you're delivering infrastructure in Wales, there are 4 potential scenarios in relation to impact on a national park and AONB. So first, the proposed infrastructure is in a national park or an AONB, and it is major development. The second is that there is proposed infrastructure again in the park or the AONB, but it's not major development. The third is the proposed infrastructure is outside of the park or the AONB, but it will be visible from inside one of those areas. And then fourthly, the proposed infrastructure is outside the park or the AONB, but there are views of the national park and the AONB from outside of those areas, but which would take in the development if it were to be constructed. So those are the 4 scenarios. If we then turn to Planning Policy Wales, the general introduction, of course, to this section tells us about the rich and varied landscapes and calls them iconic and talks about the importance of those being protected because of the contribution they make to the distinctive cultural identity of Wales. So that's the kind of intro that one gets to those policies. Obviously, that is very Welsh specific. One doesn't see anything like that in the English policies. And it does set a context for the importance of this. We've then got what I call the Great Weight policies, and we have similar in England, as you all know. But in national parks, great weight to be given to the statutory purposes of national parks, which is to conserve and enhance natural beauty, wildlife, cultural heritage, and also to promote opportunities for public understanding and enjoyment of the qualities. There's then a reference to the social, economic, cultural well-being, which is a separate statutory duty. And then AONBs, again, great weight to conserving and enhancing beauty. And then an express statement that in landscape and scenic beauty terms, they're given the highest status and indeed equal status in Welsh policy. And then major development, which I'll obviously be talking about a fair amount over the next 15 minutes or so. Special considerations apply to major development, which is said to be proposals that are of more national than local in character. Major developments can only take place in, note the language, national parks or AONBs in exceptional circumstances. And this may arise where, after rigorous examination, there's demonstrated to be overriding public need, refusal would be severely detrimental to the local economy, and there's no potential for locating the development elsewhere or meeting the need in some other way. And then there are 3 criteria, which I'll come back to, I won't look at now, which must be considered if you are looking at something that is major development in a national park or an AONB. And then more generally, the policy goes on to talk about special qualities of these designated areas that must be given weight in both development planning and development management process. And there is a need for careful assessment of impacts on features of national parks and AONBs. There is then some sort of bespoke guidance in relation to minerals, which I won't touch on today. It's slightly outside the subject of what I'm discussing. The other sort of national level policy that one has to be aware of in relation to this is if one is dealing with an NSIP, if one is dealing with an energy project, one has got EN1, so one of the national policy statements, again emphasises higher status of protection given to national parks and AONBs, assumes rightly, of course, that all development that's caught by EN1 will be major and therefore has to meet the bulleted tests, which are similar to, not exactly the same as we'll see in a moment, but very similar to those one sees in the PPW itself. And then just briefly on the legislative provisions, in terms of national parks, the purpose of national parks: conserve and enhance natural beauty, wildlife, cultural heritage, and also promote opportunities for understanding and enjoyment of those special qualities. There is, of course, under 11A1, a separate duty to on national park authorities to foster economic and social well-being of local communities within their parks. And then 11A2, in exercising functions in relation to a national park, if there's a conflict between those two purposes, so if there's a conflict between the conserving and enhancing of natural beauty, wildlife and cultural heritage and the promoting of opportunities for the understanding and enjoyment of those by the public, then the balance in that conflict situation has to go in favour of the natural beauty, wildlife and cultural heritage. That applies to any function of any relevant authority that deals with a national park. And this is, of course, the Sanford principle, which has been with us since 1974, now in statutory provision. And you may have seen last week, after I had written these slides, we have effectively the first case that's properly looked at the Sanford provision in England, a case called Stubbs, decision of Mr. Justice Dove, where he held that the Sanford principle actually only applies if there is what he'd called an irreconcilable conflict between those two objectives. Otherwise, the Sanford principle didn't bite. There had to be this irreconcilable conflict, not just a conflict between those two purposes, for the Sanford principle to bite. So that's the Stubbs case, if you're interested in that provision. And then in terms of natural beauty, the 1949 Act provides that conservation of natural beauty of an area includes conservation of its flora, fauna, geographical and other features. And Section 99 of the NERC Act, which, as you may know, was introduced to deal with the decision of the High Court in Merrick, which was later upheld by the Court of Appeal, and which effectively extended the definition of natural beauty to not be prevented from applying where there had been some human intervention in the landscape. And then on AONB 85.1, the 2000 Act, in exercising performing functions that affect areas of natural beauty, relevant authority shall have regard to the purposes of effectively conserving and enhancing that natural beauty. So if we just turn to major development, and obviously when we're talking about infrastructure projects, most of those are going to be major development. Where we're dealing with proposed infrastructure in a national park or an AONB, the first question is it major development? Because if it is, you have to meet the exceptional circumstances test. And it is important that this major development test only applies in the national park or the AONB, not outside it. That's clear from the language of the policy. And in this regard, the language of the policy in Wales is identical to that in the NPPF, and that was considered in the Stroud case, where Mr. Justice Easley upheld that view. What is major development? topic in and of itself. Of course, it's very largely undefined in the PPW, as it was in English national policy until the 2018 NPPF, when we got footnote 55. But what is clear from case law in England, and I think there's no reason why this would not be applicable in Wales, is that it does not have the same meaning as major development under Development Management Procedure Order or similar. What is major development is a more nuanced, fact-specific question when it arises in relation to these policies. Obviously, any major infrastructure project is likely to be regarded as major development. Any nationally significant project automatically would, whether that's nationally significant UK-wide or Wales-wide. Just to note, though, the definition of major development in Wales is different to that in England, because the PPW says major development proposals which are more national than local in character. So by definition, major development in Wales is about things that are more national than local. That wording used to exist in England in PPG 7. It's long gone from English policy. And that means that in Wales, there is a more restrictive approach to what constitutes major development and what brings in this higher exceptional circumstances test than there is in England. So just some differences between the test. I mean, first of all, the one I've just picked up there is the language that's in the Welsh policy, not in the English policy, that proposals to be major development must be more national than local. Now, the difference between Wales and England in this regard came up in an appeal back in 2011, where the inspector had to face arguments about the fact that there was this different approach between England and Wales, with a materially broader definition of what's major development, and therefore what brings in the exceptional circumstances test in England. It was noted that could cause some pretty serious problems. Take, for example, Wye Valley AONB, which crosses the English and Welsh borders. You have a different view about what's major development on one side of the border to the other. And the inspector invited Welsh ministers to consider the matter. They gave it pretty short shrift, saying planning's a devolved matter. Wales is entitled to take a different view on such matters, although I don't think any explanation was given in the decision letter about why a different view is taken and why it is right to have a materially more restrictive approach in Wales. Other differences, the language is subtly different. In the NPPF, we've got exceptional circumstances in the public interest. The Welsh policy has other wording, like the need for rigorous examination. That used to exist in England, is gone. Not sure much turns on that. The language is different in terms of how you characterise the exceptionality in the public interest in England versus overriding public need in Wales. And then the main text in the Welsh policy repeats two matters that are also in the criterion, the three criterion that we'll come on to, one of which is impact on local economy. And I think one does see, and I'll touch on this very briefly a bit later on, one does see in Welsh decisions much more focus on what the impact would be on the local economy of not allowing a proposal that was major development in an AONB or a national park. And then one's got the three criteria that you have to apply in relation to major development. And note in England, the language is different, because in England it does refer under that third criterion to recreational opportunities and any detrimental effect on those. That's not specifically referenced in the Welsh policy. In Wales, here's the three criteria. The need for the development is one thing you have to consider. Alternatives, the cost and scope of providing the development outside of the designated area or meeting the need in some other way. And then the detrimental effects. And in Wales, that's focused on environment and landscape rather than recreation. Although, as we saw earlier, EN1, like in England, in the NPPF, does in fact refer to recreation under this third criterion. So how do you satisfy the test? What are the relevant principles around that? Looking at some of the English cases on the similar but not the same test in the NPPF. Mevagissey Parish Council, the judge said that the policies meant you can only grant major development if there are exceptional circumstances, and exceptional here means rare. And it's demonstrated that despite giving very great weight to, on the one side of the balance, conserving the landscape and scenic beauty, the development is in the public interest, or in Wales, one would say there's an overriding public need. And then importantly, those three criteria, which everybody focuses on, and we've just looked at, are not exclusive considerations. They are things that must be considered, but they are not the only things that must be considered. Just looking a bit further at that second criterion, which was considered in that Wealden case in England, and the wording here for this criterion is identical in Wales and England, points out everyone treats that second bullet as being about alternatives, although it doesn't actually specifically refer to alternative sites, but in many cases that's what one will be looking at, alternative sites. And importantly, the Court of Appeal said the policy does not prescribe for the decision maker how alternative sites are to be assessed in a particular case. It does not say that this exercise must relate to the whole of a local planning authority's administrative area, or to any larger or smaller than that, any area larger or smaller than that. It will depend on the circumstances. So there is flexibility as to how one approaches that alternatives test under the second criterion. Wealden is quite an interesting case because I don't think it could possibly arise in Wales. I mean, there the development was for 103 homes in Sussex, and that was regarded as major development. I don't think there's any way, if you treat major development as being something that's more national than local, as Welsh policy requires, that you could ever regard 103 houses as major development under the Welsh test. But that was a test there, and the question that arose was, how far did the applicant have to go in looking at alternatives? Was it the whole district, the whole of the south of England, or, as the court upheld, was acceptable just in the town and immediate environs where this scheme was promoted? So flexibility on how one applies alternatives test in that second criterion. And then, interestingly, the case law in England also says this exceptional circumstances test is not as high a test, this is useful if you're trying to promote development, not as high a test as one has for greenbelt release and development in the NPPF. And then just on legal principles, just touch on one case, which is a Court of Appeal authority from Wales. Court of Appeal upheld a decision to grant a major development in a national park, despite an officer recommendation for refusal, concerned the Bluestone Holiday Village on a 200-hectare site. And factors that were upheld as relevant to the decision included that the PPW allowed consideration of the impact of permitting it or refusing it upon the local economy. And I've said this does seem to be a particularly important factor in the Welsh decisions that I've looked at. The court noted that, of course, economic considerations are also directly relevant in national parks under Section 11A. Secondly, they emphasised, in agreement with what was said by the Court of Appeal in the Luton case in England much later, that this test is lower than the Greenbelt test, and that the relevant factors in that case included the fact this site was close to the edge of the national park, that there was other development just outside the park boundary, which also had an impact, and that there were landscaping proposals which would have effectively mitigated part of the scheme. Now, I won't spend time on these. I've picked out 3 or 4, I think, decisions, not all that recent, that I feel have done quite a good job of looking at the major development test and reasoning it through. 3 of them are grants, the first 3, the 4th one is a refusal. I won't talk about them now, but I do think one of the themes that emerges, as I've said before, is a stronger focus in Wales on what the effects are on the local economy, both the positive but also the negative. If you turn this application down in the national park or AONB, how bad will those consequences be? What will be the loss to the local economy? I won't, given the time, talk about those, but I'll move on to look at wider issues. So what if you're not dealing with major development and the major development test? Often a lot of the debate is about whether something's major development, but of course the policy protection in no way ends there. And Mr. Justice Holgate's recent decision in the Monkhill case is useful here. He was looking at paragraph 172 of the NPPF, that's the great weight policy give great weight to national parks, AONBs, which is of course also in the PPW. And he held that is capable in itself of sustaining a clear and independent refusal reason for a planning application. And he said in a simple case, where there will be harm to an AONB, or we can add national park, but no countervailing benefits, there's obviously no balance to be struck, and the effect of giving great weight to them would have to be looked at in that situation, and you'd be looking at a refusal. But where there are countervailing benefits, it's evident or self-evident the issue for the decision maker is whether those benefits outweigh the harm. But the significance of the latter being increased by the requirement to give great weight in every case to the landscape, etc., that you are protecting. So when might you be dealing with all of this? Well, two situations where you've got a development in an AONB or national park that's not major development, or you have development whatever scale, so a nationally significant project outside the AONB or the national park, where the major development test is inapplicable. What's relevant then is the great weight parts of the policy, and Monkhill is a useful guide, albeit it's of course an English case. And then it is worth just touching on the Stroud case finally. English case again on the policies in the NPPF, the great weight policies in the NPPF. But the wording very similar here, and I think the reasoning in Stroud would apply in Wales, or should apply in Wales. Now, the judge in Stroud was considering paragraph 115 of the old NPPF, which said great weight should be given to conserving landscape and scenic beauty in AONBs, which have the highest protection in relation to landscape and scenic beauty. That's now obviously in 172 of the NPPF. The wording in the PPW is practically identical for these purposes. The question that arose was, what was covered by that policy? So what did that policy bite on? The first thing the judge held was that it included views from the AONB, we can add national park, into the surrounding landscape, effectively taking the view that the beauty of the AONB would be harmed if, looking out of it, one saw ugliness. And so the judge said that the inspector was correct and would have been unrealistic if he had said, actually, no, this great weight policy was not applicable when one was talking about the impact on views outside the national park, looking from a national park, from an AONB, towards some major development. The great weight policies do bite in that situation. But what it did not include, according to the judge, was a view that you have outside an AONB or a national park, a view that takes in both the national park and AONB and the proposed development. So if there is a development that's going to pop up in a view of a national park from outside the national park, the judge's view is that those policies, the great weight policies, do not bite in that situation. That's not to say those things are not relevant considerations. Yes, you certainly can take into account the impact on that view, but the great weight policies in the English national policy, and for me the same would apply in Wales, would not bite in that situation. And then briefly, just two examples from Welsh decisions which have looked at these issues about development outside of national park. And I think the second one in particular is an interesting application of that principle. I think that covers everything I wanted to say, and I'm going to hand over to Heather, who's going to look at EIA and habitats.
Hi everyone, as James said, I'm covering the EIA and habitats, two aspects of the infrastructure consenting regime that project promoters, of course, have to take very seriously. I'm going to start with habitats first, actually, because from an infrastructure perspective, there's more to say on that in terms of recent case law developments in particular than on EIA. And I just wanted to start by recapping Article 6 of the Habitats Directive for anyone who's not perhaps painfully familiar with it already. Article 6.3, this requirement applies to a plan or project that's not directly connected with or necessary to the management of the site. And I've paraphrased Article 6.4 here. There are additional detailed requirements which we'll come back to look at shortly. What I'm going to do is to focus, of course, on habitats cases that are relevant to the development of infrastructure projects specifically. There are a number of points that have emerged in the last couple of years. We'll start in Wales, and then we'll look at one case from England, and then spend some time looking at what the European Court of Justice has had to say in relation to the rest of Europe that's also relevant to parties who are promoting, or indeed parties who are opposing, Welsh infrastructure projects. I want to start with the Court of Appeal decision in Mynydd y Gwynt. I'm sure many of you are familiar with it. It concerned, as Russell said, a proposed wind farm near the Ellenydd Matline SPA. The DCO application was refused because the Secretary of State wasn't satisfied that there would not be an adverse effect on the integrity of the SPA. What happened was, at the DCO examination, the position ultimately taken by Natural Resources Wales was not that there was a real risk to the red kite population, but that the claimant hadn't provided enough evidence to show that there was not a risk. The DCO examiner concluded that the claimant's survey data provided a reasonable degree of certainty, that red kites on the project site didn't actually originate from the SPA or from its buffer zone, so consequently the project wouldn't result in likely significant effects either alone or in combination. So the DCO examiner recommended approval, but advised the Secretary of State that in the light of NRW's concerns, she might decide that an appropriate assessment was necessary. The Secretary of State requested further information from NRW and from the claimant on the red kite issue. The claimant didn't respond, and NRW reiterated that the information available wasn't enough in its view to reach a decision that there wouldn't be an adverse effect on the integrity of the site. So the Secretary of State undertook an appropriate assessment. You can see here in this slide the concerns that were raised by NRW. So doubt over the origins of the red kite that were using the project site, uncertainty over proposed mitigation, concerns about in relation to the age and the methodology of the surveys, and NRW was also concerned about a lack of information about in-combination effects. Then we have the Secretary of State's reasoning. So she reasoned that the burden of proof, she said, was on the claimant to demonstrate that the proposed development would not adversely affect the protected site, and it wasn't on the NRW to demonstrate that harm would occur. And she felt that she could only grant development consent if there was a positive assessment of an absence of an adverse effect on integrity, and she didn't think she had the information before her to satisfy her on that point. Her reasoning was upheld both initially by the High Court and then subsequently by the Court of Appeal. This is a passage from the reasoning of the Court of Appeal, and you can see in particular factors that the court thought were especially relevant were, first of all, that the Secretary of State was having to balance two important social objectives, so renewable energy on the one hand and species protection on the other. There'd also been, as I've explained, a conflict of views between NRW as the statutory conservation advisor and the DCO examiner. And then when the Secretary of State had requested further information, NRW had provided some and the claimant hadn't. In terms of the detailed arguments that are considered in the Court of Appeal judgment, we have some guidance, first of all, which I think is useful more generally beyond the facts of this case, as to what the requirement under the domestic habitats regulations to provide such information as the competent authority may reasonably require actually means. And as you can see, the Court of Appeal has taken a fairly relaxed view to the scope of that requirement, saying that there's no reason to put a limit on it, and it extends beyond raw data to explanation, analysis and professional opinion. My view is that's not a surprising take on things by the Court of Appeal, because the legislative requirements would be rendered a lot less effective if the requirement to provide information could only encompass raw data. The Court of Appeal then went on to say that it didn't think that using the expression burden of proof was helpful in the habitats regulations context, but that the High Court had been correct to say that the burden is on the applicant for a DCO to ensure that the competent authority is provided with sufficient information to convince it. There was then also an argument by the claimant that it had effectively been required to prove a negative beyond reasonable doubt, so to prove an absence of adverse effect on integrity beyond reasonable doubt. But the Court of Appeal rejected that and said, no, the Secretary of State was only asking for clarity, not for absolute certainty. And the other point that's interesting from Mynydda Gwent is the rejection of an argument that the Secretary of State's decision on Mynydda Gwent was inconsistent with the conclusions that she had reached in the Mid-Wales inquiry and also in the Bryn Blaen decision. The reasoning behind that was that the Court of Appeal noted that there hadn't been any connectivity in the Mid-Wales case between the Mid-Wales sites and the SPA, and NRW's advice in the Mid-Wales case had been different, so the Court of Appeal didn't think there was an inconsistency there. And then on Bryn Blaen, the Court of Appeal reasoned that because that was a later decision, it couldn't of itself vitiate the Secretary of State's decision in Mynydda Gwent. The overall point that I would take away from Mynydda Gwent if you're promoting a project is that it's safer to err on the side of providing too much information than too little, because if the decision maker decides that they haven't got enough, it's likely to be pretty difficult to challenge that decision after the event, as the court cases on Mynydda Gwent show. I should add that Mynydda Gwent was recently considered in the litigation on the airport's national policy statement in relation to the third runway at Heathrow, and the particular point that arose there was what the standard of review was to be applied when considering whether there's been a breach of either Article 6.3 or Article 6.4 of the Habitats Directive. The Divisional Court in the Heathrow case held that the standard was Wednesbury irrationality, relying on the Mynydda Gwent case, and the claimant in the Heathrow case argued that that was wrong and that it was proportionality. But the Court of Appeal has confirmed that the Divisional Court, and therefore also the Court of Appeal in Mynydda Gwent, was correct, and the standard of review remains therefore Wednesbury irrationality, which means that overall it should be quite difficult for claimants actually to challenge successfully exercises of judgment in relation to the various aspects of Article 6.3 and Article 6.4. Moving then briefly into England, this decision, I think, and the reason I picked it up is because I think it might be of interest to anybody involved with road schemes, or equally by analogy, I think, other linear projects such as electricity projects. The challenge was brought on SEA grounds as well, but we'll focus briefly on the habitats angle. And the relevance of the case is that the High Court gives some more thought to when there will, or in this case won't be, a plan or project for the purpose of the habitats regulations. So as you can see, this was a judicial review challenge to the Secretary of State for Transport's decision to accept a recommendation for Highways England on the choice of a preferred corridor for the proposed Oxford to Cambridge Expressway. But no habitats regulations assessment had been carried out. The Secretary of State argued successfully that there wasn't a legal requirement to undertake HRA at such an early stage prior to any definite decision on the corridor or the route having been made, and that the habitats assessment would come as part of the DCO process. That reasoning was accepted by Mrs. Justice Lang, and she's also provided some further reasoning about when there will or won't be a plan or a project for the habitats regulations. One of the key points that she reasoned meant that there wasn't a plan or a project was that the decision didn't prevent consideration of routes outside of the preferred corridors at a later stage. So it was a step taken in the course of preparing a project, and it wasn't itself a plan or a project. Also, she reasoned, I think correctly in my view, that the decision wouldn't actually be likely to have a significant effect on the special areas of conservation, because in itself it wouldn't obviously result in the execution of any work or any intervention in the environment. And some of you who've had to grapple with this issue of when there will or won't be a plan or project might have come across the Commission in UK case. But Mrs. Justice Lang reasoned that in that case, the statutory development plan did have a considerable influence on development decisions, and therefore could have an impact on the protected site, whereas the early stage decision on a preferred corridor in the Berks Bucks case didn't have that level of influence over future development so as to amount to a plan or project. So I think the takeaway point from this case is if you are at a very early stage of working out the route for a linear infrastructure project, then you might well not need to undertake habitats regulations assessment until a later stage in the development of the project. Moving then over to Europe and to a number of cases actually that the European Court of Justice has handed down in the last couple of years that are relevant to infrastructure. I just want to give you the headline points on those. First of all, people over wind, hopefully lots of you are well familiar with this by now. The short point to take from that decision is that mitigation measures shouldn't be taken into account at the screening stage. So when you're deciding whether or not you actually need to undertake an appropriate assessment, you need to disregard those. For further consideration of people over wind more recently, in domestic courts, there are two decisions of Mr Justice Dove that I've set out there, Canterbury and Gladman, that make clear that basically people over wind is the law and previous inconsistent domestic case law authorities are no longer good law. We come then to Grace and Sweetman, a decision from a couple of years ago, again featuring the frankly indefatigable litigant, Mr Sweetman, who's been to Luxembourg several times. This case might be of interest to you if you're dealing with a project that involves changes to areas of forest, which Welsh infrastructure projects not infrequently, of course, do. The factual context is that this was an application for a wind farm actually in an SPA, but the conclusion reached was that there wouldn't be an adverse effect on integrity. And the proposed development included a management plan, the point of which was to ensure that the total area of habitat that was suitable for hen harriers wouldn't be reduced. The background to this in more detail is that if apparently, I didn't know this, but apparently if forest is simply left to mature, then it stops providing suitable foraging habitat for hen harriers because it becomes closed canopy and that's not what they like. So on the facts, the extent of suitable habitat within the SPA was in constant flux depending on what stage of forestry management was in play, and the population of the birds varied in accordance with that. The management plan was intended therefore to ensure that overall there would always be the same amount of suitable habitat available, so at no point would there be a reduction in the extent of suitable habitat for the birds, and actually it might even be enhanced. But what would happen is that some of the site would be made unavailable as appropriate habit for the duration of the lifetime of the project. The aim was to manage the special protection area dynamically in the sense that the areas suitable as hen harrier habitat would vary geographically and vary over time. So Ms Grace and Mr Sweetman argued that the management plan measures were compensatory measures and they weren't mitigation measures. So they couldn't be taken into account under Article 6.3 in deciding whether or not there would be an adverse effect on integrity. And if anything, they could only be taken into account at the later Article 6.4 stage of the analysis. The European Court recalled the distinction that it's drawn consistently between mitigation measures, although it doesn't actually like that word, but mitigation measures that are effective to avoid or to reduce adverse effects so that there simply isn't an adverse effect on integrity, and measures that don't avoid or reduce adverse effects but rather compensate for them. And as many of you will know, it's only the former, so only mitigation measures that can be factored in at the Article 6.3 stage, and compensatory measures have to be left over for Article 6.4. And on the facts in Grace and Sweetman, the court considered that the future benefits to be derived from the adoption of the management plan measures were not sufficiently certain to allow them to be accounted for under Article 6.3 as mitigating measures. So they had to be left over to the Article 6.4 stage of the analysis. The next case then is Holohan, again an Irish case that concerns the extension of the Northern Ring Road of Kilkenny. The proposed road actually crossed to Natura 2000 sites. So the question was, it's quite an important one actually, the question was whether an appropriate assessment under the Habitats Directive has to catalogue all of the habitats and species for which the site in question is protected, And also, do you, in an appropriate assessment, have to assess potential effects both on the species that are present on the site, but for which the site isn't actually listed, so the species that aren't the reason why the site is protected under European legislation? And secondly, do you also have to assess potential effects on habitats and species that are outside the site boundary? The reference to site here is a reference to the protected site, not to the project site. And the European Court of Justice has given extremely clear answers, actually helpfully, to both of those. So yes, you do have to catalogue all of the habitats and species for which the protected site, is protected in your appropriate assessment. Although essentially what they're trying to say in the second part of this first bullet point on this slide is that if you're not going to be affecting a particular habitat or species, then probably you don't need to worry about those too much. And then secondly, yes, you do have to think about the species that are present on the site, but for which it isn't listed. And you also have to think about habitats and species outside the boundaries of the protected sites, but only to the extent that your project is liable to affect the conservation areas of the protected site. So essentially, things happening outside the protected site might be relevant, but only if for some reason there's I imagine a factual connection between what's happening outside of the protected site that means that for some reason there would be an impact on the conservation objectives of the protected site. The almost final habitats case that I want to just mention briefly takes us then to Belgium. This was in the context of Belgian legislation providing for reactivation of a nuclear power station for a 10-year period, and also for a deferral by 10 years of the date that had initially been set for deactivation of another power station that was still active. Unsurprisingly, in my view, the court concluded that there was a project for the purposes of the Habitats Directive and that an appropriate assessment was required. But the point of relevance really beyond the nuclear power context is that this case provides some very rare guidance from the European Court on Article 6.4 of the Habitats Directive and what's known as IROPI, so imperative reasons of overriding public interest. So I've just recapped Article 6.4 here. Essentially, if you are going to have an adverse effect on the integrity of a protected site, then you need to establish that there are imperative reasons of overriding public interest, or IROP. And particularly relevant in the context of this case is the second bullet point. So where the protected site hosts what's called a priority habitat or priority species, then only certain considerations can be raised as part of your IROP case, including public safety. So in Inter-Environnement, the European Court reasoned, the reasoning really is relevant to security of electricity supply, but I think the reasoning would also extend more broadly to anybody really who's promoting or seeking to challenge an energy project that's concerned with security of supply. In any event, the European Court has confirmed that the objective of ensuring security of the electricity supply in a member state at all times does constitute IROP for the purpose of Article 6.4. However, if you are dealing with a protected site that hosts a priority habitat or a priority species, then the court has been clear that only a need to nullify a genuine and serious threat of rupture to the member state's electricity supply will be enough to amount to a public security ground within the meaning of Article 6.4 in those circumstances. Finally, on habitats, before I turn briefly to a couple of points on EIA, there's another Irish case that concerns a gas terminal, and we've had the Advocate General's opinion on this and are awaiting the European Court's judgment. The facts here were that consent had been given for a project, but it hadn't been commenced during the initial 10-year life of the consent. Excuse me. And Advocate General Cocotte has reasoned that where you're looking for an extension of a project in those circumstances, then further assessment will be required, and essentially an extension of the original period of time in which to implement a project amounts itself to a new project that requires further assessment under the Habitats Directive. There's some interesting and more detailed reasoning in the Advocate General's opinion, so we'll have to wait and see whether, if the Court of Justice agrees with her, it also picks any of her more detailed points up. But just an important case to keep an eye on if you are in a position where you've got an infrastructure project and you've already passed the end date for implementing it, or you're coming up against that. Just be aware that the requirements in relation to habitats regulations assessment might kick in again. Turning then to EIA, the two cases that I want to mention briefly are cases that we've already seen in the habitats context. So first Holohan and then Anti-Environnement again. So in Holohan, there's some consideration first of all as to the extent of the information that has to be supplied in an environmental statement, and confirmation from the court that the developer has to supply information that expressly addresses the significant effects of its project on all the species identified in the environmental statement. So it doesn't have to explain all of the effects, only the significant ones. Not really, I think, telling as much that we didn't already know or couldn't have worked out from the terms of the directive, but slightly more illuminating is this aspect of the Court of Justice's reasoning, where it says that the developer must supply information in relation to the environmental impact of both the chosen option and of all the main alternatives studied, together with the reasons for his choice, taking into account at least the environmental effects, even if such an alternative was rejected at an early stage. So what this is trying to do is to provide further guidance on the requirements under the EIA directive to assess the environmental impact of alternatives to the proposed development. I don't think it's actually the most helpful response from the European Court. The Irish court that referred had asked where you have an option that's considered and discussed in the environmental statement, or you have an alternative option that some of your stakeholders are contending for, or the competent authority itself has regard to an alternative option, then do any of those things make those options a main alternative, so that the environmental statement has to think about them, even if they've been rejected by the developer at an early stage? The answer to that question specifically appears to be yes, reading between the lines of this passage from the European Court's judgment, but the judgment doesn't expressly grapple with the detail of that question, which I think is slightly regrettable. And finally then, just popping back to the Belgian case, from an EIA perspective rather than habitats, the question here was where a piece of infrastructure is brought back into use or the lifetime of the project is extended, is there in effect a new project for the purposes of the EIA directive? The Court of Justice noted that the legislative measures that were in issue in this case entailed major upgrade work to the two new nuclear power stations in question, and it decided that the legislative measures couldn't be artificially dissociated from the work to which they are inextricably linked. So in its view, the measures and the upgrading work together constituted a single project. And importantly, the Court of Justice noted that it didn't matter in its view that the actual implementation of the legislative measures would require subsequent acts, such as the issue of a specific consent. There was still, when you took the legislation and the work that it would be needed subsequent to that, when you took those together, there was a project, even though specific development consent might also be necessary further down the line. Again, for anyone interested in energy supply and security of supply, there's further discussion in the judgment from an EIA perspective of the circumstances in which a risk to security of electricity supply might justify not undertaking EIA. And there's also discussion of the circumstances in which national legislation is excluded from the scope of the EIA directive if at any point someone's concerned by that. So, diolch yn fawr pawb, that's everything that I have for you on EIA and habitats this afternoon, and I'll hand back to Russell for Q&A.
Diolch, thank you, Heather. Thank you, James. We've got some very good questions coming in. I think we've got time for perhaps 3 of them. I'm going to pose this first one to both James and Heather, given their workloads. It's this: the government is consulting on allowing courts below the Supreme Court to be able to depart from pre-exit European Court decisions. If that power was given, your views, please, as to whether the English courts would overrule People Over Wind, and in particular what it says about taking into account certain mitigation measures, and go back to Hart and Smythe and the other cases that Dove spoke to, given that the Court of Appeal in those cases has called the view eventually taken by the European Court in People Over Wind as, quotes, lacking common sense and being absurd, close quotes. What's your view, James, Heather, on that?
Well, I mean, I think from my perspective, I think there's a pretty strong chance that if our courts below the Supreme Court were given a free hand, they would go back to what we had before, given how strongly they rejected the approach that was finally taken in People Over Wind. The only thing is, I think that over time, People Over Wind has become sort of a bit more embedded, and it's kind of been accepted as it has to have been and analysed in some cases. I guess one thing that, even if they decide not to completely overrule it, which maybe they won't now, I don't know, but they might be given a bit more flexibility to decide that some things are not mitigation but are part of the project and therefore can be considered, because there is this emerging division, isn't there, that the Langton case picks up on, between something that's mitigation and something that's truly just part of the project. And I think if you take an extensive enough view of that, you can probably undo some of the damage without overruling it. I have to say, I don't know if anyone's interested in the overruling power. There's a really excellent submission that's been made by the Bar European Group about why the government shouldn't do this and allow courts below the Supreme Court to overrule. One of the reasons being the potential for all the courts throughout the UK, so Scotland, Northern Ireland, Wales, having different views on whether a European court case still applies as law, is going to be an absolute recipe for disaster. Whereas at least if the Supreme Court's the departing court, you've got some overall control over our whole system, but we'll see.
Heather?
Yeah, I mean, I broadly agree with James. I think the position was so sort of clearly to the contrary before People Over Wind came in that I suspect it is likely that domestic courts might seek to go back to that if they're allowed to. But I also, I do think the distinction between measures that are part of the project and measures that are mitigation is very difficult. And it seems to me that if we were to revert to the pre-People Over Wind position, then we wouldn't have to grapple with that so much, and it would be more straightforward, which aligns, I suspect, with where the government in particular would like us to end up in terms of all forms of environmental assessment, not having them being an obstacle course, which, despite what the domestic courts have said time and again, frequently they still are acting as that.
Yes, I tend to agree with you both. Heather, on the Belgian case, the renewal case that you mentioned, we've got a question here which says, we're tending to assume that the application for the renewal of permits must involve some works, not just a continuation to operate as normal, in order to attract the EIA obligation. What's your view on that? Is it just continuing, or is it continuing with works which somehow trigger some development control consent?
I think it's actually probably the time frame of the project that's likely to mean that even if you're just carrying on as normal, you might still need to reassess, because if you've initially done all of your assessment work on the basis that it'll be operating for a set period of time, and then you decide actually it's going to carry on for another 10 years, I can't see how you can, I'm not sure you'll have done the assessment work at the outset to say that you don't need to do it again because you've already thought about that. So I certainly don't think it would be safe to just assume that because you're carrying on as normal, albeit for a longer period of time, none of these assessment obligations bite, because it seems to me that they would do.
Because you wouldn't have assessed necessarily the significant environmental effects beyond the time frame that were set out in the ES.
Yeah.
Okay, James, one for you. Here it is. Are the differences between the major development policies in England versus Wales deliberate, or as a result of the failure to update the PPG7 wording in Wales?
Well, in my view, it's definitely because of a failure, an inadvertent failure to update the wording back from PPG 7. But that 2011 decision that I referred to seems to me to be a suggestion by the Welsh ministers that there's some deliberate choice by them not to have updated the wording. But they don't give any explanation about what that deliberate choice is based on. And I mean, frankly, I think in reality, it's much more likely to be inadvertent. I think it's unfortunate for two reasons. I mean, one is it's unfortunate to have departure on these things between England and Wales when there isn't really a good reason that I can see for having a different view. And secondly, you know, if you are interested in protecting AONBs and national parks from major development, then you want a test that captures sufficiently what is major development. And the reality is, it looks to me like it's going to be much narrower, the definition in Wales than in England. Therefore, you don't apply the higher test to a lot of development that you would apply to it in England. And I'm not saying that development can't go forward, but if it is going to go forward, it probably should go forward having applied those higher tests. But there we are.
Of course, we've got a new framework coming in Wales, which will form part of the development plan for the purposes of Section 38. And I'm sure that those who are framing that will have a view to ensuring that there are differences where there need to be and that there aren't where there don't need to be. I mean, obviously, planning in Wales is now very different from planning in England for good reason. But I agree with you that where the changes are really hangovers from past drafting, they ought to be reconsidered, and the need for an alteration also considered as the new document is drafted. Well, one last one. I'm interested in your views as public lawyers here. Recently in PMQs, the PM said that he would get the M4 relief road delivered for Wales. This led to the First Minister responding by saying it was solely a decision for him and that it wouldn't be done and that alternatives are being considered. Does the UK government have any power in delivering an M4 relief road around Newport? Now, Heather's been involved in this directly, so I'll start with you.
I suppose I haven't, to be honest, I haven't ever considered this from a legal perspective, just because politically it seems to me that that would cause ructions that probably mean it's beyond funding. I can't really see Westminster seeking to do that. So, yeah, off the top of my head, I can't see a way that that could be done in a way that would be kind of legally possible and also politically remotely acceptable. But I don't know, maybe James has a different view.
Well, I'm not sure about, I don't think there's a way that's politically acceptable, but I mean, presumably, if they really did want to do it, they could use primary legislation to deliver it, a hybrid bill, effectively. I mean, there's no, I mean, it would itself, I think, create a bit of a mini constitutional crisis if they did do that. But Westminster would, I think, be entitled to make that legislation if that's really where they wanted to go. But I think, Heather, for the reasons you've said politically, I just can't see that happening. But
I agree, and I think in the dark annals of my memory, I'm remembering it right, that the powers that were devolved to Wales theoretically could be recovered by Westminster by primary legislation, but I just don't think it's going to happen. I think much more likely is something that's almost happened in the past, which is that the Westminster government would recognise that it's politically and at the present time legally inappropriate. It doesn't have the planning powers, it doesn't have the highway powers to actually consent a road, but it does have the financial clout to underwrite it. And that's what's happened in previous schemes where the Cameron government said that it would, even though planning powers and highway powers had been devolved, help underwrite and fund a new relief road because it had cross-border implications both in England and in Wales, which would benefit UK as a whole. So I don't think it is a realistic position whereby the UK government would any longer have any power to deliver in a consent sense, in an administrative law sense, but they could make it very difficult for the Welsh government by saying that they would fund it to 2/3 or 3/4. and then the Welsh Government would have to consider value for money and all of the other things that I spoke to in my talk. So I think that's the answer to that question. That's it. I think we've grossly overrun, and it's my fault entirely. But I hope you've all found it useful. Diolch am eich cwmni. Thank you for your company, and have a great rest of the day. Diolch. Thank you very much.